Can a caregiver receive an inheritance from their client?
Keith, we see this one a lot. We have a caregiver that is living in and taking care of somebody, or maybe they're a next door neighbor, but they're a caregiver in the sense that they're coming over and changing diapers and taking care of a person that's elderly and infirm. And the elderly and infirm person gets a good relationship with them and says, hey, my kids don't come around. Nobody cares about me like you do. I want to give you some of my estate. And it's a very uncomfortable conversation, but ultimately that is what the decedent wants to do. Can that happen?
So generally speaking, no. And so in California, we have a whole set of statutes under the probate code that is generally referred to as prohibited transferees. And so there's people who are prohibited from receiving gifts under a trust or will. And that would include people like the drafter. So if somebody drafts a trust or will, like a lawyer, you draft up a trust or will for a client, you can't name yourself as a beneficiary. Well, that makes sense. We shouldn't allow that. And the same goes for caregivers. And part of the reason for that is it's natural that an older person who's depending on this caregiver for their means of living, because the caregiver might be administering medicine, helping to get their food and drink, and taking care of them, naturally you're going to develop a very strong affinity for this person if you're an elder person. And it's not uncommon for them to want to leave something. And plus, the elder could be susceptible to undue influence and fraud. And therefore, under our prohibited transferee statute, it specifically says that a caregiver cannot take under an estate plan, and what it does is it raises a presumption of undue influence. So the caregiver is presumed to have gotten that gift through undue influence, even though that may or may not be the case. And the caregiver could try to overcome that burden with proof, but it's very, very difficult, nearly impossible, to try and prove the absence of undue influence once that presumption arises. So for all intents and purposes, the bottom line answer is caregivers cannot receive under a trust or will.
Albertson and Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson and Davidson, LLP.